Oh, hey, I guess we're live today without our intro and stuff. Well, that's very interesting. I wonder why that happened. Well, I guess it happened. So maybe I'll do this. Hey, I'm Michael Bryant. This is Just Serve TV. Guess who's not here? Linda Kenny Baden. She is on assignment. But I have a very special guest, a guy that you'll know from our good old days at Court TV. I'm sorry, Law and Crime, one of those. He was just on Court TV. So if you were tuning into Court TV and you go, wait a minute, I think I just saw that guy. Well, in fact, you did. I'm just looking over some of our details here to see why, for some reason, we didn't have our usual goodies at our command. Very interesting. Well, I'm gonna have to figure that out. I'm gonna throw this in there for you then. All right. So I guess StreamYard has decided to be a little bit wackier today. Justice, where are you? Okay, so it's kind of our abbreviated version of what the hell's going on today. I can tell this is going to be fun. I've got a gut feeling. Before I forget, we're going to be giving away some memberships at some point today. So I think what I'm supposed to tell you to do is go to make sure your gifted membership button tag is on YouTube. Okay, go to your gifted membership little switchy and make sure that's on, because we're going to be giving away some stuff. Okay, so now without further fondue, Bob Bianchi. This may be one of the few times we've actually been on together, because one of the things we thought Law and Crime should have done better, to be honest, is had the host kind of interact and discuss. And we did it a few times, but I was there about 7 years and a handful of times that we ever did it. So I am very happy to bring to the stage former prosecutor from New Jersey, all-around great guy and attorney, Mr. Bob Bianchi. Bob, thanks, buddy, for joining. I appreciate it.
Hey, Michael, man, I'm like super impressed. I thought maybe you didn't have your initial setup because you want to introduce me to get me on as quickly as possible, but obviously that's not the case.
Yes.
But when I did see what you got, the Scales of Justice, your guy's name on it, I'm now replacing the Jersey Girl only for one show, because nobody can replace the Jersey Girl with the Jersey Boy. I'm proud to be on. I love you guys. You guys are doing great work. I love what I'm looking at.
Thanks, man. We appreciate it. We're just fumbling our way along. I don't know what the hell happened with our technical stuff on the intro here, but the important thing is here. That's you. So what we're going to talk about today, a little case out of Massachusetts, the Karen Reed case. Of course, what we had today was the continuation of an evidentiary hearing, the Daubert hearing, the Lanigan hearing, if you're in Massachusetts, to determine whether or not this dog bite expert, Dr. Russell, was going to be allowed to testify in the second case, the second trial. Obviously, everybody knows the Karen Reed case. She's accused in the death of her boyfriend, cop John O'Keefe, who died in January. In fact, coming up on the anniversary of that death. It was the 29th of January, a couple of years or so ago. And the first trial didn't end so well for the prosecution. There are still some issues up on appeal, as you know, Bob. Count one, count three. Did the jury determine unanimously that she was not guilty of those counts? And why didn't the judge ask about that? And now that's up on appeal to see if that's even going to exist in the second trial, which we learned today is officially set for April 1st. There had been, Bob, I don't know if you remember, there was a discussion where both the defense and the prosecution said, we got to push this off. It was originally scheduled for the 27th of this month. But because of these appellate issues, they said, no, let's put it off. It was a mutual request. And April had been talked about. I don't recall an actual hard date ever being set, but today the court said it's April 1st. So we got to jam through a lot of these matters. So what do you, let's just jump into the appellate issue. What do you think about this issue with the jury and the apparent unanimity on the two counts?
Yeah, Michael, I mean, like what else could possibly happen to the prosecution to bollocks up, have a more disturbing kind of case? As a former homicide prosecutor, I want my cases to go in clean, right? I want them not to have appellate issues. And all I see the prosecutors doing between the witnesses they're putting on the stand and the manner in which they're going about doing what they're doing, including today, which I think is really, from a tactical and legal standpoint, I said on Court TV, as you mentioned before, is lunacy to me, what they're doing. It shows me either amateur hour or desperation, combination of the two, I don't know. But all this is it's up in the appellate division. What the appellate division will do, I don't know. but this should have been ferreted out at the time of the original trial. And in the end analysis, we understand that a defendant's constitutional right not to be tried twice for the same crime, double jeopardy, is extremely important principle. It's a constitutional bedrock foundation principle. And all I can say is, who knows what's going to happen because of the malfeasance of what went on with the trial court and the trial prosecutors below. But it's giving the defense the vibe, the vibration of strong. They're getting stronger and stronger. It just keeps getting worse and worse for the prosecution. And last point I'll make on this. You know, when I prosecuted murder cases, I can honestly say that even though I tried a lot of difficult cases to success, things that evidentially were tough cases, I was always convinced that the person I was prosecuting was guilty of the offense. I have to be honest with you. With all of the shenanigans that have gone on here, including the manner in which this investigation occurred and didn't occur, I have serious doubts as to the guilt of the defendant. And as a prosecutor, if I genuinely held that I felt that I had a doubt, a reasonable doubt, I didn't go forward with the prosecution. I was obligated to do that legally, ethically. And this is how innocent people get convicted of crimes they didn't commit.
Yeah, you know, in my notes, one of the things I wrote down was desperation, because it just sounds like if they care this much about this one particular witness, I mean, it's a lot. You know, Shakespeare said it best. Methinks thee doth protest too much. I mean, let's say this. What if she gets excluded?
Look. This is the point, Michael. I mean, a trial is not brinksmanship. It is an uneven playing field. It was constitutionally set that way. And as a prosecutor, you don't we've done analyzing court TV cases on TV for years. And what has always shocked me is how many prosecutors are out there that just want to hear the words guilty, but aren't really thinking about what happens when it goes on appeal, gets reversed, and has to come back and be retried. Michael, how many cases have we covered over the last 6 years where that very thing happened? I don't understand that. I never had one singular case ever reversed in a murder case. I knew my case inside and out. I put evidence on, and when things got sticky, I worked through it, not around it. So this is what they're trying to do here. They're essentially telling the defense, we don't want you to have any witnesses. The judge has already ruled that these witnesses are admissible. They clearly are over the Daubert. That's the standard, the Daubert standard with regard to their testimony. These are issues as to what the prosecution is arguing that we say go to the weight of the testimony, not the admissibility of the testimony. Any basic trial lawyer knows the distinction between these two things. Is it admissible? The judge makes a decision. If the judge says yes, that doesn't mean that the prosecution has to roll over. They can argue that the jury shouldn't give that testimony any credibility. But Michael, to outright ask a judge to ban testimony that the court already said met the Daubert standard and is admissible is a huge sign of desperation. And they don't care about a reversal, because that's exactly what this will cause. The judge will never grant this motion. And you know what? They've lost credibility with the court, in my opinion, in making it prosecutors, and in the court of public opinion, and certainly with this TV legal analyst. It's amateur hour.
Yep. And we've seen through the course of the first trial and everything they've tried to throw at the wall in the post first trial, pre-second trial, that you were a prosecutor. You tell me, you get a hung jury, even if this one had little issues that may or may not have been hung. You sit back and you say, okay, let's reevaluate this case. Let's take a hard look at this. Do we go forward? Do we just lick our wounds and move on to the next case on the pile? These guys seem to be, doubling down, saying, not only did we lose, but we're going to get you better the next time. And they've begun that process with all these motions and other pretrial shenanigans. Is that odd to you?
It's odd to me that their way of going about it is to say, let's just preclude the defense from putting any witnesses on. I mean, I guess you could do that. It's unfortunate those witnesses are in the way of your conviction, but that's the way our system operates. You have a right to put on witnesses. So that's number one. But is it odd that you would double down? Well, I've thankfully never been in a position where there was a not guilty, or certainly a hung jury, a not guilty. That would be the end of it. But I can understand where you're like a dog with your teeth in a bone, when you're prosecuting a case or you're trying a case. I get it. I was that guy. But I always took a step back if I felt at a certain point in time that there was something being presented to me that made me, Bob, do I need to reconsider my position? So a prosecutor, a good prosecutor, is going to be like a dog with that teeth in a bone, but always has that thing in the back of their brain where they're saying, let me back up here because I'm not omnipotent. I'm not perfect. I can make a mistake and I need to reevaluate. Those are tremendously powerful and good and decent prosecutors that do that. Unfortunately, what I do see, Michael, and I don't even know if we want to go into this area, prosecutors aren't being trained properly on the philosophy of prosecutions, in my opinion. That's number one, like we were trained. And secondly, when you're dealing with elected district attorneys, I don't even want to get into it. It's hard enough to do your job. I was appointed by the governor when I was the prosecutor. That's how we do it in Jersey. And still, there's a lot of pressure on you. There's a lot of court of public opinion. And you've got to be strong and steel yourself to say, I'm going to not let the tail wag the dog. I used to say to my staff all the time, Michael, look, forget about the media. Forget about Michael and Linda and what they're going to say about us. Forget about all that. It doesn't make a difference. We're going to do what we think is the right thing and walk out with our heads held high, whether we win or lose, as opposed to doing the wrong thing and walking out with your head held low because you did the wrong thing. But what I see with elected district attorneys more and more, and it's becoming more difficult, even from Michael Nifong, the Duke Lacrosse case, all the way to the present era, is that they're catering more to votes and to public opinion than the court of law. And I can't help but think that this is all hands on deck because there's ego at play here and they don't want to relent because they'll look bad. And that is antithetical to what it is that prosecutors should be doing.
Yeah, we saw that with the Daniel Penny case, 11 days after the act, before he's even charged. And then obviously Justice Erb was in the courtroom there for that case, and we saw it unfold to what I think is the right conclusion. But again, you could argue that DA Bragg sat there, put his finger up to test the wins, and when people were protesting outside his office, said, maybe I ought to charge this dude.
Yeah, Michael, listen, you know what shocked me recently? Like, I guess in the last 5-10 years or whatever, things have changed so much. We literally have district attorneys running for office and campaigning on actually prosecuting people. Now, I don't want to get political here, but there was one political figure of great, significance in this country, maybe going to be president of the United States in a couple of days from now, that people were literally like, I couldn't believe this. I don't care whether you love the guy, I don't like the guy, I could care less. But like literally you're campaigning on prosecuting the guy. This is something that my ethics as a young assistant prosecutor and then as the head county prosecutor, one of my assistant prosecutors ever came up or I found out said, I'm going to prosecute this guy and do ahead of time, went out publicly and said they were going to do that before they had all the evidence, reviewed the case and made the decision through the court system, you'd be fired in a nanosecond.
Yep. It's a different time. You're right. And I guess on Friday, that person you might be talking about is going to be sentenced for what could possibly be the purpose for that? I'm working on getting on down there to do that too, because I think he's not going to be there. He's going to appear virtually, Mr. Trump, that is. But it's still going to be a circus. It's still going to be, historical and not necessarily in a good way. Okay, let's do what we came here to do, because I believe your time is very valuable, sir, and I want to look at some of the activity from today. And just kind of scroll through some of it because it was a long day. It was a very, very long day, and I think that most of the activity took place, as they were really getting kind of warmed up. But I really want we got some new bodies in this case now, Bob. Both sides brought in some new hired guns, and I think it's important to get a feel for them. We did a little bit in the first round of this particular hearing, so we did learn a little bit about the different players, but I think it's so critical to see how these guys perform in front of a jury, and I'm talking primarily about Hank Brennan, who is the hired gun prosecutor that's come in, getting $75,000 up through June. After that, they have to renegotiate. I'm not sure he's a bargain. I don't know. But I think it's good for people to just kind of see this guy in action.
I had asked you if you had expressed any uncertainty in the past about your opinion. as it relates to the opinion you gave at the Lanigan hearing, at the last hearing, whether your position has changed or evolved is what I'm getting at. And you said that your position has not changed. Is that right?
That's correct.
You were asked at the trial about the injuries and how you think they happened. I want you to turn to the trial transcript.
Again, before they get too much into this, she's the dog bite expert. This is Dr. Russell. She's basically said there's no way any car bumping into John O'Keefe caused these injuries. And we know there's slashes and gashes. And we also know, the theory is that this car backed into John O'Keefe, somehow caused these abrasions, cuts, scrapes, bites, in her opinion. And so the goal of the prosecution here is to get her out of there because she's the only one that's made any opinion about the cause of those scratches, bites, claw marks, whatever they may be. So they're working hard to discredit her.
If you turn to page 19, line 21.
Nineteen,
Page
Line-
19, line 21, may I approach, Your Honor?
yes.
So the page number.
There was a
here.
point earlier today, Bob. I thought it was embarrassing. They didn't have a copy of the transcript for her of either the prior voir dire, of the prior trial testimony, or of the first part of the hearing. If you know that your cross is going to be based almost entirely on those transcripts, don't you think maybe you'd have some copies ready to go?
Oh man, Michael. I mean, this is trial school 101 where you teach your people to have your trial notebook prepared, to have copies of every exhibit, not just one for the witness, for the court, for the court clerk, and for your adversary. It shows that you're a professional.
Yep. And you know what they ended up doing here? The judge called a halt and said, look, here's my copy. Go make copies of this. It was just, just so Bush. I couldn't believe it.
But Michael, I mean, honestly, you bring this point up, and I'm really glad you did. I mean, nobody else is bringing this kind of thing up.
Do you recall
It tells you that this is amateur hour. It's illustrative of how they are sloppy.
Yeah. So Brooklyn says they ran out of money for transcripts. Yeah, I guess that's possible. But yeah, these are, this guy, he comes from a big firm, Hank Brennan. He's not a first timer. He's not a, fresh out of school. I'm amazed. You got people. Don't you have people? They've got, 3 attorneys at least sitting there, not to mention they got the whole DA's office at their disposal if they need it, right?
Michael, I'm sorry. I got to ask you. Brother. Talk to me. Talk to me here. Maybe you know something I don't know. How embarrassing is it that they've got to hire an outside attorney to come in and prosecute a case?
Yeah. Well, how'd you like to be Adam Lally? Sitting there. I think, he certainly had the opportunity to say, I've done this once. Thanks a lot. Have a nice day. But he's sitting there reliving this like the little kid sitting in the corner with the dunce hat on because he didn't do it right the first time. I don't believe it.
And by the by, having run a prosecutor's office, you don't need to go to law school. You don't need to be a super duper prosecutor. You don't have to be even a smart person or even marginally intelligent to know. Michael, tell me if I'm lying here. You allow the guy who lost the case, give the case to an outside person to come in to still be involved in the case. There's going to be so much jealousy and rancor and anger and finger pointing and kitty boo boo. I used to call it kitty boo boo. About that. Like, what are they thinking? And one last point. I don't know how the format of the show goes.
This is it. This is how it goes.
Hey, Bob, just shut up. Okay. Here's another thing. This guy, big law firm. I'm so sick and tired of listening to that. Every person, I'm not saying virtually every person I've heard comes from the big law firm means nothing to me. Nothing. Give me a scrappy trial lawyer in a 1 or 2 person law firm that sits there and has to eat everything he kills. That's the kind of lawyer I want to pick. Number 1. Number 2, I'll tell you why strategically this guy's already, in my mind, a little bit of a joke. I'm sorry. I guess I could do that being an armchair quarterback now. I'm not in the courtroom. But I'm going to tell you why I'm not impressed. I'm not impressed. You're just giving up to this witness. You know she is going to be allowed to testify. The court has already ruled she's going to testify. You are not going to win the Daubert argument. You're not winning it legally. But you know what you're doing by getting up there and questioning her? You know what you're doing? You're telling the defense where you're going to go in front of the jury. You're giving them a preview. You're not keeping your powder dry. It's amateur hour, Michael.
And and we saw it today when redirect took place. It was the best rehab ever, and a preview, as you say, of what they're going to use in court, except it'll now be on direct because they already know what the cross is going to be.
Exactly. And so I love it. I mean, I love the format of this show. I love it. Yes. So here you go. Now I know this is the defense lawyer, right? And I know where the cross is going. So when I'm doing my direct examination in front of the only people that make a difference at the end of the day, the jury, I'm already prepared and target hardened for what that cross is and how to get around or in front of any issues that need to be gotten in front of him. Where's that going to leave the prosecutor on his cross-examination? Sucking his thumb.
Yep. And I think a lot of it too will play out not so well in front of this jury because of this guy's attitude. Now, maybe, he's Jekyll and Hyde, and this is just for the judge, this performance. But he's not very likable, Bob. And as I've said many, many times, never underestimate the power of likability. He's arrogant. He's annoying. I don't even know if he's ever right because he just annoys me so much. I think that you can't discount that in front of a jury.
No, listen, when I train trial lawyers, I tell them all the time, Michael, for 30 years, it's about your likability and your credibility. Those are the only abilities you need to know when you walk into that courtroom. You don't have to. I've seen so many lawyers go in there with this level of arrogance and that they're the smartest person in the room, which you're not, because if you were, you wouldn't act that way. And they go in, and if is a prosecutor especially, I need to say, and I would always say in opening statements, and I know it's very contrary to what people do say, but they say, whatever we say in the opening statement is not evidence, and, don't hold me accountable. No. I tell the jury, you hold me accountable. If I say anything to you right now that is not accurate, at the end of the day, you should hold me accountable. Why am I doing that? Because everything I'm saying, I know I can prove without any question. But from the get-go, when that jury's listening to me, they know I have confidence in my position. I'm now building credibility with that jury, and I make sure I can deliver on every promise that I'm going to try to deliver in a courtroom. It's never failed in terms of credibility. So you don't have to be smart. You just have to be believable and likable. And a lot of times, I hate to say it, but the evidence, the science shows it. If the jury believes you're credible and likable, they'll listen to what you're saying and likely go your way.
Yep, they'll give you the benefit of the doubt. Yeah, I used to tell them, write down these things I'm telling you that we're going to show. Write it down, and then when it comes through the end of the trial, if you can't tick off each of those items that I've promised, then you got to hold it against me.
Yeah, and alternatively, when you sit there at summation, see, because I know you probably got a lot of young lawyers or trial wannabe lawyers or just true crime aficionados. When you're trying a case, it's not like throw it. I've listened to people say this: throw it against the wall, and whatever sticks is good enough. It is everything should be planned in order. So not only in my opening statement, not only am I preparing my case for my summation. Let's start with that from the beginning when I first get it as a prosecutor, especially, and building my way backwards in order to build the evidence necessary to say what I want in summation. But when I'm in that opening and I'm saying, you hold me accountable, I have what I told them listed. At the end of the day in summation, I'm going to be up there and saying, did I not tell you that we would prove beyond a reasonable doubt? Point one, we did for this reason. Did I not tell you? Point two, point three, point. Now, however, let's look at what the attorney said in opening statements in his opening or her opening statement that did not come true. So I've seen so many times that being so effective, game over before you even look at the evidence.
Yep. Okay. So, and again, as it relates to the new hotshot, Mr. Brennan, let's listen to, and I think I have this queued up here properly. The key that the argument he was attempting to make to discredit this witness was that she had no methodology for her dog bite expertise, and so he really beats that like a dead horse. And it gets to be insufferable, but let's listen to just some of it. Let me see if I can cue it up to about the right spot here and let him roll.
And did it talk about a standard of practice of methodology?
Recommendations.
No, but that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
He's talking about an
authors
article.
that were practitioners, and they weren't, I don't believe they were in a position to create a standard.
In fact, you can't point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites. You can't point to one article, journal, book.
That's correct.
And so because there is no methodology or standard for you to look at.
Now she gave him a toehold there with that response, but they did a great job on rehab. So I'm not going to beat her too badly for that. I do want to listen to a point I think the prosecution made, that I actually didn't know going into this. I thought I kind of knew her background, but the question was how she became involved in the case. So listen to this.
A differential diagnosis that you didn't write down.
Not that I remember at this time.
And that's why it helps to write it down.
That's coming up here in a second. What he's giving her a hard time about here is that he was asking her, well, did you consider this? Did you consider that in your differential diagnosis? Did you consider that? And she would say, no, no, no. I mean, he could have said, did you consider being shot? Clearly he wasn't shot. So it makes it look like, well, you didn't, throw everything into the frying pan and you just focused on what you wanted to find. Okay. You might have made a couple of points on that. Not a big deal. But how did she get involved in the case? That was most interesting.
One of those causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes.
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
I thought I could clarify the issue of what those wounds were caused by.
So you were learning about information about the case publicly before you got involved in this case, didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan, I wasn't following the case at all. I don't even subscribe to the Globe for information about this general region.
You don't have to be defensive about it. I'm just asking you.
Okay.
You knew enough that you wanted to get involved and you made some phone calls to offer your services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming what at that point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again,
Michael, can I
I
stop for a
know
sec?
that there are very few people in this.
Yeah, I mean, this is exactly what I'm talking about. These questions, as inartfully as they're being posed, go to the credibility of the witness. They don't go to the admissibility of this hearing. I want your audience to understand, just goes to whether or not it's scientifically reliable, not whether she's believable or not believable. Does she have the credentials, and is it scientifically reliable? Everything he's doing right now, he's prepping the defense for on direct examination to now say, how did you come to us? And tell us about why it was you came to us. They're going to get ahead of it now because he's giving it up. I'm sorry. I just had to give it up.
And I think that makes the point. I mean, this is stuff that I don't think was all that out there. And it is a little unusual. I think you'd agree for an expert to, call up, hey, I've been seeing a little bit about this case, maybe I can help. That's unusual, right?
Exactly, and you know what? It may actually score points with jurors when they're what's happening. But I'll tell you who it's not scoring any points. Zero points on the board with the judge, who's only there to determine whether or not it's scientifically reliable, and she's an expert. Whether she's credible or not is for the jury to determine.
Yeah, and that's obviously the closing argument that was made today by the defense counsel. But let's listen to some more of this again. I think she got a little befuddled because of this revelation that she injected herself into the case to some degree.
This country that have the combination of experiences that I do, and I thought that I could just clarify the issue and maybe, help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
I knew that a police officer had died. I was a former police officer, so I knew a police officer had died. And I knew that there was a trial, and I didn't know details really. I just knew that I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Had you seen any photographs?
No.
And so just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
Correct.
Okay. So when you ruled out motor vehicle accident, is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you considered car accident as not part of the cause of these abrasions?
That was not the only reason.
That was one of the reasons?
Yes.
Did you look at the wounds and you thought based on the accident there would have been broken bones or other injuries?
That was one of the reasons.
Okay, so now they're moving on into more of this differential diagnosis stuff, and I want to get into some related issues. And as you can see, we've gifted 5 Justice Served memberships, so I think you have to have your gifted membership tab on. I don't know what that means, Bob, but that's what they're supposed to do. So anyway, okay, so back to one of my original points was, so let's assume, I think we both agree, she ain't getting excused. She, if they want her to testify, she will get to testify. Everybody can argue as much as they want about her credentials, her credibility, etc. Let's assume she's bounced for some reason. How does the prosecution get around the fact that you've got 2 independent federal experts, part of a federal investigation, who have already testified and plan to testify again that the car did not strike John O'Keefe? So to me, that is far more insurmountable than did the scratches, were they caused by a dog or when he fell on the ground, however he fell on the ground. What do you think?
So, Michael, before I answer that question, I want to go to this testimony about the lack of injuries for a second. Because as you know, the judge will charge the jury at the end of the case that you can find things based on evidence or the lack of evidence. Now, I'm an emergency medical technician, an EMT. And even in EMT school, when we talk about the mechanism of an injury, and certainly a doctor can testify to this, we talk about car accident cases. Are you in the vehicle? Are you outside the vehicle? Did the vehicle roll over? Were you ejected from the vehicle? Is it a vehicle on pedestrian? Because we know before we go to the scene, depending on what mechanism of damage was occurred or how it occurred, you know how catastrophic probably the injuries are going to be. This is not guessing. This is scientific. This is medical science. Keep in mind that part of the argument is that at 12:45 a.m., the prosecution, I believe, is going to say that the car traveled 60 feet at 24 miles an hour, 24 miles an hour, and struck a vehicle on pedestrian, if you will, hit. And I think that you don't need to be an expert to know that you're going to see significant damage different than the damage that you saw here. That's point number 1. Point number 2 that you're bringing up is, what other, I'm sorry, you were just bringing it up. You just said to me, what was the thing you just said?
Yeah, the experts that already testified as independent experts that this car never ran into any John O'Keefe body part.
Okay, so this is getting, thank you. This is, getting older. This is what's happening, right? So when we talked before about as a prosecutor, what should concern you? If I were a dog, on a bone with this case, and somebody came up to me as an EMT or a medical professional and said, somebody getting hit at 24 miles an hour should have this kind of level of damage, I'd have to sit there and say, you know what? That's common sense to me. I don't need to be an expert. A jury's going to see that too. And then when we're talking about 2 other experts were hired by the Department of Justice, another, if you will, a partner in crime, a law enforcement agency with a higher probably level of expertise than who
they're on your team.
They're on your team. And they're telling you that this did not happen as a result of being hit by a vehicle. These are the kinds of things I was talking about before, Michael, that make you at a certain point say, just being a tough guy is not enough. You have to be smart too. And at a certain point in time, a tough guy even says, you know what, maybe I got this wrong. I need to really look into this. Instead, what is their answer to your question? They're trying to exclude those experts too.
Yep. Yeah. That's just... This just handed me, oh, wait a minute, let me see if I can do this here. Stand by, because I don't get to use this very often. Let me see if I can find this and use it. It's, I appreciate that it was created for us, and had we not had some issues with our thing, I would have done this differently. But now. All right, I think that's more official, Bob. That's more, that's it's definitely a breaking news now. So the deal is, as you suggest, they filed a motion to exclude the two guys who testified from, it's called the ARCCA, which is the federal agency that did the investigation into these this alleged contact, Andrew Rensselaer and Daniel Wolf. So, and that was just filed today. So it's almost as if they sat back after round one of the attempt to keep the dog bite expert from testifying and said, what else can we do to try to limit their evidence that has sunk our ship so badly? And I don't care what you call it. A hung jury is a loss for the prosecution. And so how do we head that off at the pass? Well, let's do this. So this is going to be the subject of the hearing. They put the schedule together. I think they're going to be back at it on, I think it's the end of this month. And then, let me double check the dates here. Check your calendars. Put this on your calendar if you can. Let's see. Hold on. They're going to slop over into February if they need to, but they're trying not to. And the judge, this is when the judge reinforced, hey, we got an April 1st trial date. So, we're not going to futz around with this any longer than we have to. So you guys get your heads together, and we're going to schedule these as quickly as we can. And it's going to be the end of the month on the 27th, it looks like. And then on the 7th of February, if necessary, this will be the subject of that hearing. Is that going anywhere? I mean, wait, in case you didn't know, the grounds for their attempt to limit them, obviously they can't limit them on any sort of Daubert issue because, they were already allowed in and they're already experts. So, not unlike the dog bite doctor. No, they say that there's some procedural problems. And I'm not all that familiar with MRCP, the Massachusetts Rules of Civil Procedure, or Criminal Procedure 14, but it has to do with discovery, when it needs to be provided, when you need to respond to it. I don't know how this could possibly be an issue, Bob, since they got all of this stuff during the first trial. They know who the people are. They know the reports. What could they be using to exclude these witnesses?
Your guess is as good as mine, Michael. I did the same thing. I looked up Rule 14, and I'm like, I don't understand it.
I went looking through it. I said, they must have gotten the names. These are the same names. They're not new people. They're not new reports.
Again, I mean, you just can't, because these people hurt your case, say, I just want to exclude them. That's not how the law works. I mean, what's next when the judge denies that motion, which the judge will? Are they going to like gag and ask the judge to actually remove the defendant and the defense attorney from the courtroom because, every time the defense attorney asks a question, it's hurting my case? I mean, come on, put the big girl pants on. If you're bringing this case and accusing somebody of murder, your answer isn't to eliminate all of the witnesses, including federal officials that investigated the case. You should be maybe reconsidering whether this case is a legitimate one to bring. Michael, listen, I hate to keep pounding on the same thing. You don't have to say I just had a dismissal of a homicide case. Pretty big as a defense lawyer. Had a dismissal. We were in the middle of a Daubert hearing as well. We got a dismissal on the case. The prosecutor dismissed the case. They did the right thing. They didn't say specifically that the person is innocent and they charge an innocent person, but they said, based upon what the defense has developed during the course of this case, our position is we can no longer prove the case beyond a reasonable doubt. That is what prosecutors are supposed to do. That is the standard. And instead of trying to exclude my witnesses that they didn't like because it showed that their cause of death was wrong, we showed the right cause of death. Nobody knows better than Linda Kenny Baden about cause of death and things of that nature. They made a mistake. They missed something. And they were at least grown up enough to say, it's time to let it go. When I was a young baby prosecutor, and I had a case one time, I remember it was a little wobbly, and at first on paper, it looked amazing. It looked a robbery murder case. It looked like 1,000% guilt. But as I was pulling on threads and interviewing witnesses, like more and more problems started developing in the case. And I went to my boss, and he said, Bob, you've convinced me there's enough doubt here to dismiss this case. don't worry, do the right thing. Maybe they're guilty, but you know what? You have an obligation to follow the evidence. The evidence is going downhill, and it's better to, do I have to say it? Better that a guilty person be freed than an innocent person be convicted. I don't think we're seeing that here in this case, Michael.
Well, and again, we've seen it in other cases recently. I don't know if you remember Ty Tucker. Remember the guy who represented himself down in Florida? It was in a murder case, and he got a hung jury representing himself. The DA said, or actually in Florida, they called him a state attorney. State attorney said, nope, we're going forward. And just recently, they pled it out, basically a slap on the wrist for the guy, time served while he was in custody, and it's done. But they were ready to go. They were going to go after this guy again.
Listen, you know, as a prosecutor, there's a lot that goes on. There's a lot of bravado that goes on in our profession. I don't have to tell you. Losing to a pro se defendant is it's like you need to hang up your take your badge out. I'm sorry, you know, to your boss. I gotta go. I gotta go to an insurance defense firm. No disrespect to insurance.
Hey, wait a minute. I did some insurance defense. There was a time where one of the assistant state SASs, I guess they call them, state attorneys. And anyway, it's a junior. He got her kicked off the case because she had done some things, got her disbarred. The guy, the defendant did. So, you know, pride goeth before a fall.
Yeah, wow. You know, small pebble can overturn a large carriage.
Wait a minute. Let me write that.
My great grandfather.
I don't have that one. Okay, good. Okay. Let's delve into a little more of this again while I'm before I've totally lost everything. Let's see. Is this the right piece of paper? Let's see. Let's go to. I want to look at. This is where he starts criticizing her about not going to the scene, which then boils over into, well, you didn't interview Chloe the dog. I mean, it was bad.
And so when you were excluding these causes, you have no idea his body position or angle, correct?
I went through various scenarios in my head.
But I'm asking you, not the scenarios in your head, Dr. Russell. I'm asking you about detail, fact, science, okay? I'm asking you, do you have any idea the position of John O'Keefe's body when he allegedly was struck by the car?
Objection, Your Honor.
No, I'm going along. I considered multiple scenarios.
Tell me the...
And before she moves on, you know, there was an objection to the reference to being allegedly struck by the vehicle. Earlier in the day, this guy didn't say allegedly. They had a sidebar to hammer this out, but he must have said 5 times in a row when John O'Keefe was struck by the vehicle, when John O'Keefe was struck by the SUV, when the SUV backed into John O'Keefe. I mean, you know, just shameless.
Those are fancy big lawyer tricks, big law firm tricks.
Yeah, but you know, again, as you've mentioned, that may work to some degree in front of a jury. The judge knows what the hell's going on, but you just can't let it go. You know?
Tell me the facts you have. You can tell us how is his body postured on fact. What facts do you have?
Again, I considered multiple scenarios.
When you... Did you go to the scene of where Mr. O'Keefe was found lying on the ground? Did you go and visit the scene?
No.
Did you take and look at photographs of the scene?
I looked at some photographs.
What did you see in those photographs?
They were very difficult. It was very difficult to see much useful information in the photographs.
Well, when you're engaging in differential diagnosis and you're excluding causes of abrasions to Mr. O'Keefe's arm, wouldn't it be important to either go to the scene or look at clear photographs so you could see all the debris and the land and the turf and see what it looked like? Wouldn't that be important?
No, in the 30 years of emergency medicine experience I've had, I've never gone to the scene of a car accident victim that was brought into the emergency room.
And you've never gone into court and testified as an accident reconstruction expert?
A reconstruction expert? No,
You've
but I've
never-
testified about vehicle accidents.
And you've never gone to court and
Victims.
testified as a dog bite expert before this case, yes?
I was never asked.
Right. And so when you say what you used to do, you treated people who came in with injuries. I'm talking about when you're going to exclude something as a cause. I'm asking if you have any experience in actually going out and looking at the facts and using science to exclude something fairly.
I used medical science.
Do you know what the ground looked like where Mr. O'Keefe lay that morning?
There was snow.
Now, how many inches of snow were under his body?
Under his body?
Yeah.
No.
Do you know what the ground was? Do you know if it was smooth like a turf football field or frozen jagged like dirt tends to do in the Northeast during the cold winter?
I considered several different possibilities: grass, dirt, asphalt. So I considered several different possibilities to see in my differential diagnosis.
You considered all these different possibilities, but you never even went and looked at the scene to see what it looked like, did you?
I didn't have to.
Do you know if there was twigs or roots or brush nearby?
I don't know.
Do you know if there was a fire hydrant nearby?
There was a fire hydrant
Do you
nearby.
know if there was a curb nearby?
That I don't know.
So you have no idea really, other than a fire hydrant, what this area of impact or alleged impact looked like, do you?
Well, again, a curb would not have caused those wounds, so that's irrelevant.
You have no idea.
I disagree.
Okay. Did someone tell you what it looked like?
No.
So I think she did pretty good job in that phase of the examination. What do you think about her?
I think she's fine. I mean, like we talked about before, she needs a little dress rehearsal. She needs a little. The thank you, prosecutor. You've showed us. You've given her a little dress rehearsal there. Now we're going to witness prep her for the jury for the real dance because you did what you did. But this is lunacy, Michael. It is the obligation of the investigating detectives and the prosecutors to exhaustively photo document and crime scene analyze the crime scene. Experts rarely go to the scene. In fact, if it were me and the expert started talking about what the scene was like a week, 2 weeks, 2 months, a year later, I would be objecting that that's not relevant because they can't say what the scene was like at the time the incident happened. When I investigated murder cases, we in that area probably would have had no less than 2,000 pictures. We would have had video. We would have had an entire forensic team out there so that experts could later review it. Last point, I assure you the government is going to have experts that did not go to the crime scene. Now, do I think it's a good idea to go to the crime scene? I do think it is a good idea to do that, to orientate yourself.
Just spatial orientation, yeah, but you have to do it understanding it ain't the way it was day of the incident.
Absolutely, but now the defense knows that this is going to be a line of questioning, and so they prepared her. But it is again amateur hour to me, and it has nothing to do. The bottom line here with the admissibility of this testimony, Daubert deals with is what she testifying to scientifically reliable. Is there validity to it? In other words, is it peer accepted, not peer accepted? I wrote down the areas of where Daubert is.
Yes, the five standards, the 5 rules.
5 rules.
And they're not mutually exclusive. You can have 1, maybe 2, maybe not, maybe 4, but you don't have to have them all.
That's right. You don't have to have them all, is what the rate of error. So the judge takes an amalgam of these 5 rules. And just so our audience knows, an expert testimony is a special rule in our evidence rules that deviates from most witnesses who can only talk about what they tasted, touched, smelled, saw, only their senses. An expert is allowed to give their opinion. They're allowed to opine because they have knowledge that's greater than the average individual because of their training and experience. Again, this judge doesn't care about whether she went to the crime scene or didn't go to the crime scene. The judge only cares about whether or not this is a scientifically reliable theory and whether or not this person has the expertise to testify, period. All this other nonsense is for a jury.
Yep. I'm hearing you. I hear you. Okay, here we're going to try something now. This will be fun. I'm just going to put this video back on, and I'm just going to start scrolling a little at a time, and then you say stop, and I'm going to let it. We'll see what it is. We'll have your reaction to it. I've probably seen it, but I couldn't tell you whether I remember it or not. So let me pull this up for you yet again. When last we joined our witness, she was talking about why she had not gone to the crime scene, which is fine. I think it's interesting. Oh, and later, Bob, he starts talking about, well, you didn't see the dog. You didn't make a plaster mold of the dog's bite, did you? Yeah, it got weird. Anyway. Yeah, I mean, I couldn't believe that he went that far. Okay, so anyway, let's see. Okay, there's I saw some arm photos. There's a lovely picture of the fan. We had a lot of that. There you go.
You don't know.
You
And
want
this
to?
begins or
I'm
ends.
going to start scrolling here. You tell me when to stop.
Stop.
Yes, it's page 101, line 13. May I approach to help you on that?
Yes.
And he's suggested all along, you've changed your opinion. You've changed it.
Great argument for the jury.
Yes.
If true.
Okay.
Okay. No, that's the wrong site, so we're gonna, you got that one. At that hearing, when you last testified, did you say that teeth made those marks? You are unable to say which teeth, but it was teeth?
Yes, I believe I did.
Okay, so your position from the voir dire and from the trial testimony changed regarding this wound when you last testified at the Lanigan hearing?
I still think that they are probably teeth, but I cannot 100% rule out scratch marks.
Did you say something like, I'm not sure exactly what teeth made these? They could, one of them could, one set of these could be canine, one part of this, and an adjacent incisor tooth, but I'm not sure on the second set?
Again, it goes to the fact that the wounds are not very specific for differentiating between between teeth and claw marks. However, it's in the setting of a pattern, one can get a whole lot more information, and that is supported by the articles.
So getting
Okay, so important point here that he tries to pursue. He makes it sound like if you're going to get attacked by a dog, you're just going to be static. You're just going to let it happen because if you're doing this, how are you supposed to match up that specifically? Canine teeth, claw marks, top teeth, bottom teeth. There's a lot going on. Most people don't just stand still. I've been bit by a dog. I did not stand still. You're going to react. And he makes it sound like, well, the fact that you can't pinpoint exactly what tooth made what wound just destroys your entire opinion.
Yeah, it's funny. You could have a reflexive reaction to a word, and I did. When I heard this witness say the word possible, my prosecutor and me jumped up. I don't want to hear the word possible from an expert witness. But I think that she did a nice job in recovering. And I think the point here is by this defense witness. I'm sorry, I should say the defense witness didn't want to hear possible. You don't want your expert to say possible. Is that the differential diagnosis is saying what it's not is more important than what specifically it is. And that whole idea about the pattern marks, I think, is powerful to me. I mean, does that make sense to you, Michael?
I think it does too. And I think, to your point from earlier, it doesn't take an expert to tell me if I look at that arm and those wounds to think, yeah, an animal could have done that. That looks more like an animal to me than somebody getting bumped into by a taillight that's been busted. I don't get it. And we haven't even talked about the large issue that if we look at the video of when the car was leaving O'Keefe's home with the defendant at the wheel, and she apparently bumps into his car right at this point in the taillight, right there, right? That taillight, as she drives off, is slightly broken at that point, but intact otherwise. So the timing suggests this light was wholly intact at 12:30, give or take, 5 hours earlier than when she left to go to John O'Keefe's, stay there for a couple hours, and then return to look for him and then finds him. It's almost like they're hoping you just forget that you forget seeing a video in which this taillight was intact. If the taillight was intact and you don't have shards of taillight to cut his arm, the whole thing makes no sense.
Well, let me ask you, Michael, you know this case factually a lot better than I do. So that is a very powerful point. And there's also hair or hairs of the defendant that were identified on the bumper. And I believe that there was alcoholic beverage, and he had been seen leaving with a glass in his hand and some glass that was recovered that looks as if it was glass from a bar. Okay, so those are some of the facts I'm aware of. But to the point you just raised about the broken taillight, I like if the hair got me, the broken taillight and the hair. If this is true or not true, do you believe that it's possible that this stuff was all planted there?
Well, that's obviously, the defense's kind of subtle argument, sometimes less than subtle, that it's a whole conspiracy. That, remember there was video of the SUV in the crime lab. Funny thing was the video itself was inverted so that the tail light that would have been broken is not seen. It's on the other side of the car. And obviously the suggestion is when Mr. Proctor, soon to be, I believe, former Officer Proctor, I think he's about to be discharged, he testified that they don't know how that happened. They don't know how that video got inverted. Don't know. Just
that's really odd and peculiar. But I know it's your show, and I don't want to be asking questions, but I am curious though. Is like when you put a witness on as a prosecutor, right? Each witness is strategically situated, and you don't put any surplusage on. You put on who you need, and you have a specific reason why you need them. This officer Proctor is under a lot of heat, a lot of pressure. Is no longer an officer. Was horrible on the witness stand.
Brutal.
Did the government really need him? Or is he going to testify again?
Most believe he is not going to, but then you got to fill in some holes,
right?
We won't know till we see the trial unfold. But I don't blame them for trying to work around him, but I can't wait to see how they do it.
Well,
he was the lead investigator.
How do you not call the lead investigator? This is another reason you got to look at what you want to do with this case. You had a hung jury already with the lead investigator. You're not going to call the lead investigator, which means you're going to lose something with regard to some evidence, it would seem to me, or you shouldn't have called them in the first place. What a disastrous move that was if you called them and you didn't need them. And then it also opens up the idea, will the defense call him? Which also opens up the idea is, does he have a right to remain silent because he's committed acts of official misconduct? It is a whole can of worms with this guy.
The Proctor factor, I call it. The Proctor factor. Okay, let's do one more and I'll let you go. We'll wrap this thing up. Let's do one more. Let's call this True Crime Roulette. When just tell me when, and I'll zoom ahead a little bit so we get to maybe some different stuff. But whenever you're ready.
There, right there. He looks like he's ready to make a point.
There's a different angle than here, right? But there's no flexion like in the elbow on this wound area. This is the bottom of the wrist, right?
That's correct. However, that part of the arm has a different configuration than the upper arm. And it's got it's got a bone right underneath it.
So you're saying...
The ulnar bone.
I'm sorry, I didn't mean to interrupt you.
It's got the ulnar bone. So a wound to that area is going to look different than a similarly placed or caused wound to this area, which has a lot of padding underneath it from the soft tissue, subcutaneous tissue, and doesn't have the protuberance of this bone right here.
We have a distance problem when we compare these, don't we?
We have a what?
A distance problem. The distances are different. If these are canines, obviously it's a different dog or something else that caused it because the distances are clearly different.
Who's testifying?
Right?
Well, and this is what's interesting too. I said, okay, this guy either doesn't know biomechanics even at a rudimentary level or something. He's suggesting, let's say these are your two canines, right? This is how they are in your mouth. That distance doesn't change, right? Unless your tooth gets busted. But what if you change the angle and you continue the cut? Well, then that's a narrower gap.
And like you said, the body's not static.
No.
Michael, I'm sorry, how much was this guy getting paid?
Well, he's capped at $75K, and that's through June. If the case goes beyond June, then they got to renegotiate.
They should have called me in. I would have saved them $25,000. You could pay me $50,000 to review the case. Don't
undervalue yourself there.
No, I want to do the right thing. I'm a public servant at heart. And I would have dismissed the case for you. No, listen. Okay, this guy honestly is an unskilled trial lawyer. He's an unskilled trial lawyer by the way he's asking his questions, the manner. He could have all the trials in the world, by the way. Doesn't mean he's skilled. Skilled, that's the word I'm using here. You could repeatedly make bad mistakes. I'm sorry to say that. I really am. He's making arguments that are not, going to be effective here. And now he's doing the biggest mistake you can make with an expert. I guess we're going to end your show on this very important practice point to all you true crime aficionados. I'm going to give you an example that was taught to me by my mentor on how to cross-examine an expert witness.
Okay.
He just violated it right there. You never get in the cage with a bear. You don't get in the cage. The expert is a bear. You put the expert in a cage like a bear. You lock the door. You make sure the door is locked. You get a big 10-foot pole and you go and you poke the bear and then you back up and you poke the bear and you back up. Because if you start to argue the science with an expert, no matter how stupid that expert may be, then you open the cage and you get in with the bear, you're going to get mauled. Any good trial lawyer knows you don't start mixing up the science with a person unless you are on 1,000% solid ground. And what he was just doing there about when she's arguing about subcutaneous, she'll then become a professor. She'll then become the person who's going to be super smart because you're never going to have as much expertise as she does. So he didn't learn the art of poking the bear and backing away.
Yep, so important. And one thing I do like about practicing law, especially when you're dealing with experts, is you get to become sort of a baby expert, right?
Yeah.
But if you think you're going to go toe-to-toe with the real expert, you're screwed. You're screwed. That's the legal analysis I'd put on that. You don't want to be screwed.
Screwed.
So, yeah. So just going forward, just so folks know, they did finish today. Of course, the judge did make a ruling because why would she do that from the bench? She's known for a long time how she's going to rule. But hey, let's create some drama. So she didn't rule. They'll get back at it the end of this month. There's a hearing, again, Daubert hearing, this time on the digital evidence from the car. They're claiming that the digital evidence removed from the car that determines location, speed, angle, wasn't properly removed the first time, that there's some new digital toy that will give you more information than they were able to get the first time. So that's up on the schedule. And then, of course, this hearing to see if they can get rid of the two experts who said this car never hit a body. John O'Keefe was never struck by this car. Anyway, so that's that. Bob, such a pleasure. I miss the good old days. Even though, as I told the audience, we didn't get a chance to do this very often. I can think of one or two times.
Yeah.
I think it's too bad. I think they missed an opportunity there, Law and Crime. But hey, what do I know? It's their toy box. So I hope you'll join us again. You'll squeeze LKB in here, and it'll be the trifecta. So
awesome. Thank you for having me. I really appreciate it. And thank you to your audience.
Take care, buddy. We'll see you next time.
Okay, peace.
All right, then. So that is going to do it for this issue. I'm going to figure out what the hell's going on with this platform, because we had such a wonderful set of toys to play with, and then they disappeared. Anyway, I'm Michael Bryant. I hesitate to even shut this off because I'm not sure what's going to happen. I hope we got the membership thing worked out. Diz, did we get the membership thing worked out? People got memberships? Okay. So hopefully that'll work. Cross your fingers. All I can say is I'm Michael Bryant. Try to do the right thing, and we'll see you